Yes, Mr.
Commissioner, the next witness is Kevin Michael Rudd. Yes.
May it please you, Commissioner, my name is Walker. I appear with Mr George for Mr Rudd.
Walker. Thank you. Swear the witness.
The evidence the judge shall give to the Commission shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Rudd.
Is your name Kevin Michael Rudd?
It is.
Have you provided a statement to this Commission dated 14 May 2014, which is 31 pages in length?
Can I check the length? That is correct.
Are there any matters that you wish to correct in that statement?
No.
Commissioner, can I alert you to this state of affairs as it currently stands? The Commonwealth has asked that certain parts of Mr Rudd's statement be redacted on the grounds that they attract parliamentary privilege. I understand that Mr Walker wishes to take a point or a position in respect of that, and it's probably appropriate that he can do so now so the point can be addressed, if not immediately, then first thing tomorrow morning.
I have a statement which has been heavily redacted.
Yes.
Is that the one I'm to look at, or
I think in principle it doesn't much matter which statement you have, because I think Mr Walker needs to explain his position.
Mr Walker, please do.
Thank you, Commissioner. My short answer to the question you addressed to Counsel Assisting is no. You should have, of course, the unredacted full statement, and so should the public. And so should anybody who wants to know the facts, so far as my client is concerned. The version you've got redacted, as I say, you should, for the purposes of my argument, have the unredacted version. The version,
I know I've been given both.
Thank you, yes. The version you have redacted is, with respect, correctly described by you as heavily redacted. I won't go through it now, not least out of deference to my friend Mr Howe's position, and so I won't be talking about any of the detail, but it's not merely many lines which have been taken out with those ugly black blocks that warn people there are secrets not being revealed, but rather there is a great deal of substance that is removed. The removal of all of that material as a whole, and in fact the removal of every point as it appears in the statement. So together and severally, the removal of all of this means that any redacted version of the statement is not my client's evidence. It is not his position. He will not verify, he will not put his oath to an incomplete, truncated version. Now the next point explains why he is so vehement in that position and why the necessary procedural fairness that you will be not only observing but imposing...
Half the story, does it?
Well, quite. That you will be not merely, as I say, observing, but you will be imposing it on all of us, that there be procedural fairness, requires that that be the approach. May I explain? You have heard from some ministers who had what I'm going to call portfolio responsibility, sometimes statutory, sometimes merely by executive arrangements with which you're familiar. They were the ministers administering certain programs or work. That is, by definition, something done out of the Cabinet room, as delegates, if you will, either of Parliament, if it's statutory, or of Cabinet, if it's executive. My client, the Prime Minister, is in no such position. He's the chair of Cabinet, relevantly. He is not the minister administering any of these programs out of the Cabinet room. As the chair of Cabinet, he was part of the body, solidarity of which and secrecy about the proceedings of which is at the heart of our parliamentary democracy and responsible government. At the heart. This program was a result of a Cabinet decision. This program was the subject of interim reports after it had been implemented to Cabinet, and this program was the subject ultimately of a Cabinet decision to terminate it. The whole of the story, book-ended, so far as my client is concerned, is it begins in Cabinet with material from the public service and ministers being considered by Cabinet. There is the decision of Cabinet. There are reports to Cabinet. There are reports to Cabinet under a system which involves, in generic terms, a warning. May I, without going into the detail, ask you to go to the unredacted version of paragraph 29 of the 31-page statement.
Yes.
And to draw to your attention in particular, I'm sorry to be so coy, but
That's all right.
this is the subject of redaction. To draw to your attention in particular, the sentence which starts on the 7th line, halfway along that line, it also used. Now, for reasons we cannot even begin to dream, that has been redacted. Perhaps because it is vivid and graphic as a description of a system of warnings to Cabinet.
Yeah.
Now, that's just an example, if you'll forgive me, I'll call it a colourful example, of the kind of thing which at the moment the Commonwealth position, that's the position of the executive to you, an agent of the executive, advised reporting to the executive, about the doings of this Cabinet of a former government. In our submission, it is an intolerable state of affairs that my client cannot tell the story about his involvement, which is in and through Cabinet, without being met by what is a not entirely consistent, but on any view of it, devastating truncation of the truth by these so-called redactions. Now, we don't accept that the executive appearing before you in this, an executive inquiry, has the power of veto to prevent you from looking at that material. We don't accept that. But neither, of course, and you appreciate this, I'm sure, more than anyone, you don't have the power of the judicial power of the Commonwealth to make a ruling about rights and obligations in that regard. We wish to make this clear. My client is here ready immediately to verify his 31-page statement and all of it, about which he's already been asked he doesn't want to make corrections. I suppose there's only one more question to ask is, does he, on oath, tell you that the statements of fact and of opinion contained in it are, to the best of his knowledge, true and correct? I've no doubt he'll say yes. That's what we say ought to be the course with his evidence, here and now.
Mr Walker, thank you for that. May I say that this issue of redaction has cropped up all the way through.
Oh.
And Mr Howe and Councillor Assisting have been able to sort it out each time because Councillor Assisting assures me that the bits that have been redacted would not affect my judgment or his. And you may well agree with that in respect of this statement. So what's Mr Howe's attitude to this?
May I say, no, my attitude is radically different. The redactions affect enormously the position.
Yeah, because it's only telling half the story, is what you'd say.
Or even less.
Well, I think so far that hasn't been the case. But
that's a matter for other council and other parties.
Quite so. What's your attitude, Mr Howe?
Commissioner, the claims of public interest immunity are pressed, and they're pressed in accordance with or in the light of the protocol that has been in place on an interim basis, namely that the redacted material is known to counsel assisting and also to you, Commissioner, and the witness knows that that material is known to counsel assisting and to you and can ultimately put submissions to the Commission in respect of it, and the protocol contemplates a protection in terms of the integrity of the Commission and also in relation to the interests of the witness. Insofar as counsel assisting forms an assessment as to whether he believes that the evidence of a particular witness can be elicited without manifest unfairness to the witness and without compromising the integrity of the Commission, and on each occasion up till now, counsel assisting has indicated, as it were, contentment in relation to those matters, and as I understand it, subject to some possible matters that are still being transacted between us, that is largely his position in relation to the material redacted from Mr Rudd's statement. There are a couple of propositions that I do wish to respond to. My learned friend Mr Walker put to you that that the Commonwealth doesn't have any executive power of veto to determine what material ultimately goes to the Commission and what doesn't. And with respect, we readily acknowledge and accept that. We have advanced a claim only, and we've done so on the basis that if it's opposed, then ultimately argument would need to be adduced and there would need to be evidence before the Commission, and we file that evidence and it would need to be ruled upon. So the Commonwealth is not here to assert any decisive or determinative power of veto with respect to this material. Secondly, it was put that you, Commissioner, don't have power, as it were, to resolve the issue. With respect, we don't accept that. You may not exercise judicial power in the sense of being able to finally determine the issue. Authorities are clear that in the face of a claim of public interest immunity, you ought, if pressed, hear the relevant evidence and rule upon it. And then if any of the interested parties are dissatisfied with that ruling, they can invoke the exercise of judicial power by seeking review. So ultimately, we maintain the claim of immunity. We don't assert it as a decisive veto. And as we understand it, the claim, as it were, is opposed, and strenuously so, by Mr Rudd, in which case the claim will need to be resolved by you, considering the evidence and the submissions. In relation to that, we've put our submissions in writing, we've adduced our evidence. I don't propose to detain the Commissioner any longer in relation to the Commonwealth's case with respect to the claim of immunity. I'm of course content to put oral submissions if necessary, but I'm keenly aware of the time, so we've marshalled our resources and put before the Commissioner what we want to in support of the claim of immunity. Now, if ultimately it's rejected, that is, if you decide that, having regard to the competing public interests, the public interest in favour of this material being ventilated in the Commission outweighs the public interest in favour of non-disclosure, then we, of course, would abide by that ruling, but we would at that point seek an intermediate step, namely that the material in question not be received in open session and not be ventilated in open hearing, but be received, as it were, confidentially, on the basis, though, that the parties would have access to it and would be able to ask questions in respect of it, but in a closed hearing, subject to this one qualification, namely that in due course the Commission would review the transcript of any private hearing and would hear submissions as to what part or parts of that could be disclosed publicly, and then the Commissioner would make a decision about that.
Mr Howe, my recollection of the authorities is that I actually don't have power to receive this kind of material confidentially. I either receive it or I don't. Am I wrong there?
Yes, I think you are.
Okay.
It depends really what you might have meant by the question.
Firstly, you're temporarily confidentially, you mean, and then ultimately. I don't think I can receive it confidentially, but go on.
In adjudicating the claim of public interest immunity, there is no doubt that you can privately inspect the material and form a view about it. And then, in terms of what protection should be put in place if you reject the public interest immunity claim, the Royal Commission Act itself makes express provision for you to be able to make non-publication orders as to who can be present during a hearing and as to who can access material that's received by the Commission. So you've got express statutory power to proceed in the way that the Commonwealth would press in the event the claim is rejected.
Before we started the Commission, and I thought there might be a lot of arguments about public interest immunity, I thought to myself that the members of Cabinet would be the ones who are raising it, and of course this is exactly the opposite of what I expected. But what benefit is there in not admitting the whole of this statement? I mean, people would be upset. The public in general would be upset if there was a statement admitted that was half, 50% or whatever it is redacted. And I stress I haven't read the redacted stuff. What's the public interest now if the former Prime Minister says, I'm happy to put everything on the record?
Commissioner, we've sought to deal with this partly in our written submissions, but the authorities make clear that the immunity can't be waived.
No,
not by a former Prime Minister and not by the serving
And what's
Prime
more,
Minister.
the obligation's on me, even if no one at the bar table raises it, to deal with it.
But the authorities recognise that one of the principles underpinning the proposition that the immunity can't be waived is that it is a fundamental sort of immunity of a preeminent kind. In other words, it's not an immunity that should be either applied or not, as it were, at the whim or the discretion of a former minister or a subset of ministers or even the current government. Now, that speaks, with respect, to the gravity of the public interest against non-disclosure, and it goes to what confidence existing cabinet and future cabinets can have if, in fact, the confidentiality of their deliberations can be set to naught simply because a former member of a former cabinet wishes to ventilate the material in question. So that's part. It is an enduring public interest which survives changes of government, and it survives, as it were, the particular circumstances under consideration at any particular time.
But I also have to be mindful. I mean, we agree it's a public interest point for me in the end, and ultimately for a judge if they say I'm wrong. But I mean, the terms of reference are so very wide. The processes by which the Australian government made decisions about the establishment and implementation of the program. So that while I acknowledge all of the authorities on public interest immunity, I've been charged by the government with looking at the processes by which the Australian government made decisions.
Yes, and with respect, we're not, in advancing the claim in our submission, traducing or trespassing upon the ability of the Commission to fulfil its terms of reference. And in particular, up to now, the understanding has been that the material is known to counsel assisting, and his assessment is that it won't unreasonably intrude in the Commissioner's ability to fulfil the terms of reference. Now, it's accepted that a claim of public interest immunity may have some effect on the ability of either a tribunal or a court to perform its role. The question is, will it have such grave effect, will it so fundamentally intrude upon the processes of the court or tribunal that the material must be ventilated? That's really the test which we suggest should be applied. And if you form the view that the answer to the question is yes, the material should be ventilated so that I can properly answer the terms of reference, we would ask that the intermediate position be brought into play. That is, not ventilation in open hearing, in the presence, as it were, of the public, but on an interim basis receive the material in closed hearing, it be made available to the parties, they can ask such questions as they wish, and then the transcript can, as it were, be reviewed and a decision made about publication downstream.
What does that achieve? You're letting everyone ask questions about it, but you're not letting the world see it. What does that achieve?
Well, with respect to it achieve some measure of accommodation of the...
And what if, just to speak hypothetically, there's something that I think significant there. May I write about that in my report?
Well, the arrangement that we've suggested and which has prevailed on an interim basis up till now is that, yes, the material would be known to counsel assisting and to you.
I haven't looked at the redacted material, by the way, but I know I could if I wanted to.
Would be available.
I didn't want it to affect me if it was redacted.
Right. And if you proposed to take it into account with a view to forming an adverse finding against someone, then at that point you would give notice to that person and to the Commonwealth, and there would be an opportunity to put submissions to you on the point. So the protocol does not, as it were, stand inexorably in the way of you ultimately using the material for the purposes of reaching your findings. But it does, as it were, put in place some protections which enable fulfilment of the terms of reference but respect the public interests that underpin the claim of immunity.
Mr Wilson, what do you say about this?
Commissioner, the matter was raised with you on the 17th of March, on the first day of public sittings, and since then we've danced around the topic.
Yes.
It's now been squarely raised.
Ironic that we deal with it on the last day.
Well,
It's raised.
not quite very close to the end. It's been squarely raised and it needs to be dealt with. I've taken the view, as has been pointed out by Mr Howe, that with previous witnesses, those bits that have been redacted really don't take the Commission anywhere.
No, but that's when Mr Howe is trying to redact it.
Yes.
On behalf of the Commonwealth.
Yes.
Yeah.
But this witness, through his counsel, has expressed the view that he considers it would be unfair to him if he's not allowed to tell
The
the whole story.
He's sworn an oath to tell the whole story.
If he wishes to tell the whole story, then the point needs to be decided.
Yeah.
The Commonwealth, as I understood, Mr Howe said that they have put in written submissions.
Yes.
Those submissions should be provided to Mr Walker. I understood my learned friend Mr Howe to say that he didn't want to say anything in addition to those written submissions, but he should be afforded the opportunity to if he wishes to. Mr Walker can advance the submissions that he wishes to make as to why the material should be allowed. We recognise that the privilege exists and cannot be waived, but the privilege is one that has to be balanced against the public interest. And we said on the 17th of March, and we say again, that term of reference A requires you to report as to the way in which the Australian government made decisions, and under our system of government, the way in which the Australian government makes decisions is through the cabinet process.
Thank you.
Commissioner, first of all, I'd be happy to receive Mr Howe's submission and I'll try and deal with them straight away, here and now. Second, you, with great respect, have put your finger on it. It's the terms of reference that provide the framework for the current debate. It doesn't surprise me to hear from Counsel Assisting that up until the Minister who is here because he was Chair of Cabinet, that he's been able to adopt the metaphor, dance around the matter. We don't want to dance, we want to face it frontally and march straight ahead. Now, the fact is that everything, including what I might call the particulars by way of suggestion, that the executive government, in its wisdom or lack thereof, decided to use to frame the terms of reference, places cabinet process not peripherally or incidentally, but at the heart of the first issue. The present executive, the present government, can't have it both ways. It can't require you to report faithfully on that matter and prevent you from pursuing the evidence about it, and worse, committing the unfairness of not permitting the Prime Minister of the former government to give his answer to the allegations. These are not muted allegations. They start off with the idea that this was a long weekend idea. And as you know, we have an utterly opposite version. Who knows whether we'll ever hear again about the idea that this was an idea a program whose gestation was measured in days. But we are entitled publicly to answer the suggestion that the current government, in commissioning you, decided to make publicly a public allegation as a matter of ordinary fairness, calls for a public refutation, a proper opportunity to defend yourself against adverse comment by an administrative tribunal, an investigative tribunal such as yourself, requires that match. If that match is not possible, and worse, if we are not entitled, in my client's answers in the witness box, in my submissions in open session, if we are not entitled to answer fully the suggestions that are made by the current government in its terms of reference, then your report would be impossible. Now, that is not a legally alien concept, because to go by that dangerous analogy with litigation, that is the exercise of judicial power, it is, of course, fundamental that this immunity from production to the court, which is what cabinet secrecy would produce, can bring litigation to a halt, can require a permanent stay, because justice cannot be done. There is an analogy, one's got to be careful about the analogy when switching from the judicial arm to the executive arm, but there is an analogy for a body such as yourself, which is wholly quasi-judicial in terms of the quality of the procedural fairness that you will afford. It is the current government that has brought this about by the terms of reference. We want to answer the suggestion, and we should be able to do so truthfully and fully. In our submission, there is fallacy involved in the notion of what Mr Howe seductively calls the halfway position. Can I explain?
Well, that's what I'm more interested in hearing,
Right.
actually.
You, with respect, were correct in saying that if nothing prevails against what is sometimes called the privilege or immunity attaching to cabinet secrets, then you can't receive it any more than a court could receive it. Or one could go on to complete the trio of the arms of government, or a parliamentary committee could receive it. The immunity is not respected, indeed vanishes, so soon as you see the material. And this Commission has seen the material, all of it. All the cabinet material was made available, not by us, not by some wrong, but by the executive giving it to the Commission.
But it was made available, reserving the right to argue public interest.
Maybe so, but it was made available. Counsel assisting is fully aware of its contents, so it's now impossible to maintain that this is a hearing uninformed by cabinet secrets. Nothing improper on counsel assisting's part, far from it. Nothing improper about you looking at all the material, including my client's unredacted statement. How else could you be informed? And so this halfway position has got nothing to do with an immunity. It has to do with a new form of secrecy, or, to use a kinder word, confidentiality. Secrecy is the proper word. It is keeping from the public, who would ordinarily read your report, and as we understand it, has so far had unrestricted access to your public proceedings. It is to keep from them material which my client sees as the heart of his answer to the allegations made. It doesn't help that the weasel language of suggestion is used in the terms of reference. They're allegations. And it is quite unfair and wrong of the Commonwealth, the executive, as Mr Howe appears for, to take a stance that says they can sponsor these allegations and they can stifle public answer to them. And it is wrong in law, a fallacy to suggest that it's okay for you to look at it, and I don't know how many of the rest of us in this room, presumably the families, the bereaved families, should be to the forefront of the so-called parties who would be entitled to look at this material. They want to know what happened. Mr Rudd would like to tell them what happened so far as he was concerned. In our submission, the halfway position is simply the unprincipled and inappropriate application of secrecy to material which now calls to be published because of the public way the allegations have been put. The government decided to ask you to report to it about a process which explicitly involves cabinet deliberations. Either the inquiry cannot proceed and the report cannot be made, because the Commonwealth says, though we ask you to do this, we also say there's a rule saying you can't look at the material. Or else, as ordinary common sense would suggest, we get on with it and give our evidence.
Just one thing. Is it possible to accept your submission but not go inside the cabinet room?
No. My client's activities in relation to this program are very largely inside the cabinet room.
Not just dealing with the ministers outside the cabinet room?
Oh, no. That would be absurd, not least because their dealings are dealings about their performance of mandates from Cabinet and reports to Cabinet. The allegation is made.
I would like to do this, but I don't think. I'm not aware of any authority that actually goes inside.
The reason why there's no authority, this is serious. No other government has ever decided to ask a Royal Commission using mere statutory powers, which must be less than those of a House of Parliament, in making inquiries of its ministers. No government has ever asked for cabinet processes to be inquired into like this. And the novelty only emphasises the completely alien nature of an executive inquiry, which is tasked, you are commanded to report on the terms of reference, and then the executive turns up to say, but we insist that somebody who is the object of allegations of misconduct will not be able to give his account faithfully and truly of what he did.
Mr. Walker, as I say, I'm inclined to admit it and not take the halfway house as well, knowing that will be a courageous decision. The one thing that is troubling me, though, is that there are others who have pleaded cabinet confidentiality on the way through, and I'm just wondering what will happen if something that Mr. Rudd says cuts across the area where they've been quiet and said nothing.
Right. I'm sorry, I can't offer you any real comfort on that. There may well be, as they say in the classics, some correspondence to be entered into, but there may not be, because it will, and there's been, obviously, and with great respect to my friends at the bar table, there's been common sense and judgment applied, and it will require a case-by-case judgment as to whether the item or episode in question is worth making a fuss about.
No, Mr. Howe, I'm going to admit the whole statement. Now, if you want to take that elsewhere, we'll accommodate that in some way or other by not publishing it tonight. And you can.
Now, I take it that
need to seek instructions or something like that.
Yes, I will need a short adjournment to seek instructions, but I take it what you have done in effect is to reject the claim of public interest immunity, yes. So you've decided that the material should be before the Commission in an evidential sense.
In the public interest it should be in.
Yes. Now the next step is, well, how then should the Commission deal with the material that is now received? And we've asked the Commission to exercise the powers expressly conferred by Section 6, capital D3. Now, my learned friend, I had understood, put to you the submission that the intermediate position for which we contend is legally unavailable to you. We would just want to reassure you that that is not right in our submission. You have available to you a power to receive the material, but to put in place the sort of protective regime which we are asking. Section 6, capital D, subsection 3 was inserted for a purpose. It clearly is capable of lawful exercise, and we press for its exercise, and with respect, it can't be set to naught. You can't be asked to ignore its presence simply on the basis of an assertion that it's legally unavailable. We accept that it requires the exercise of discretion on your part, and you may decline to make the orders, and we would, as it were, accept that you have that power, but we would not want you, Commissioner, to, as it were, admit the evidence, publicise it, and do so on the basis that no other option was available to you as a matter of law, because clearly another option is, namely the non-publication arrangement of which I have spoken. To receive the material, have it canvassed in private session, have it made available to the parties who have leave to appear, and then ultimately the transcript be inspected and so much of it released as you consider is appropriate, hearing further submissions from the Commonwealth. Now, if you reject that as well, then of course the Commonwealth will, I'll have to take instructions, but I imagine will abide by that ruling. But it's very important that you exercise the powers on the basis of the existence of a discretion and not on the basis of some unfocused proposition that you simply can't do it because it's legally unavailable.
Well, I suppose at this stage, Mr. Walker, that's a middle ground which it's putting off an evil moment.
It's quite.
Can we think about it more carefully?
But let me make our position clear. Whether focused or not, my submission doesn't deny the clear statutory power. You can exercise that discretion to keep anything secret. This. Mostly it's people's addresses, by the way, for reasons of security. What I said was the statute doesn't provide a means to honour the immunity. The immunity exists to prevent you looking at it and taking it into account. Once that's done, we're into a different area of simply the statutory discretion for secrecy. And for all the reasons my learned friend Mr Howes has said, of course you should exercise that discretion in the interim this evening so as not to render futile my friend seeking instructions. That's exactly what you should do.
That's certainly what I had in mind.
And that's exactly what you should do.
All right. Yep.
Mr. Commissioner, we agree that you have a discretion. My position is that we'd oppose taking Mr Rudd's evidence in private, but obviously an interim arrangement should be put in place this evening whereby the unredacted statement won't be published.
Yes, all right. Well, I make an order that the unredacted statement not be published until further order. We will therefore proceed with only the legal representatives present. And I take it, Mr Howe, you've got no objection to the Commonwealth representatives, the council assisting team being present and your solicitors being present as part of the legal teams. So it's just a case of excluding the public for the moment. Correct?
As I understand it, the Commissioner has in mind that we'd have an opportunity to take instructions on the proposed way forward, namely reception of the material and its public ventilation, but in the meantime, counsel assisting asked Mr Rudd some questions with the public excluded, but only until such time as we can indicate to the Commissioner what the Commonwealth's position is. Is that right?
No, it's not quite that. I am acceding to your fallback position for the time being, that we can have a look at the transcript ultimately and say, well, there's no reason why this should be kept private or be made public.
Yes. It may be that I can get instructions, I don't know, in the next 10 to 15 minutes, and if I'm able to, then the Commission may, depending on those instructions, be able to proceed in open session without some interim private session, and that might be preferable.
I'll just say at the moment, to help you get the instructions, my inclination is, first of all, to admit the whole statement, and I'm going to do that. And then the second question is, my inclination is to make it public, because there's not security stuff here. It's not going to affect our relationship with other countries or anything like that. As far as I know, I haven't read it. So I mean, I presume,
Commissioner.
It's not high security stuff.
Could I just say,
it's cabinet in confidence stuff.
In relation to that, we accept it doesn't give rise to national security concerns, but can we remind the Commissioner that the High Court has indicated that it can simply not, it could not conceive of any circumstances in which in any civil proceedings the actual deliberations of Cabinet could ever be ventilated. Now that, with respect, puts protection of Cabinet deliberations on a footing as high as protection of national security with respect. It is a preeminent claim based upon public interest factors which the High Court has said it simply could never exceed being outweighed in any civil proceeding. So I don't want the Commissioner to proceed in exercising the powers available to you on the basis that this isn't national security, it's just Cabinet, because the High Court has said when it comes to Cabinet deliberations, it is legally erroneous to regard it as just the collective thought processes and conversations of a coterie of people.
Secretary Whitlam you're referring to.
No, it's Northern Land Council.
Land Council, all right. That's the later one too, isn't it? Is it the later one?
I think 1984.
Yeah.
But that's the high order of public interest which underpin the claim. We're not chancing our arm with a speculative claim. As the Commissioner rightly noted, it's never been ventilated ever before, and we would just want the Commissioner to exercise his discretions knowing the gravity of the public interest for which we contend as part of our claim.
Mr. Commissioner, can I say something on behalf of the Fuller family? We adopt what the learned friend Mr. Walker said about the role and the interests and the importance of those families of the deceased who are named in the terms. It would be, I think, most inopportune for there to be some interim proceeding where members of the public, and by that do I assume, for example, Mr. and Mrs. Fuller, would be excluded. Their confidence in the process is dependent upon them having access and involvement in all of the evidence, and it's a matter of practicality. You've seen them here every day. Bear in mind the time, and any interim debate would seem to gain you only 5 or 10 minutes of real evidence if you're still going to adjourn it. We suggest respectfully that the issues that Mr. Howe raises about Northern Land Council case have some force, and that consideration of the best process whereby the Commission can properly proceed so as not to necessarily impinge upon both the interests that Mr. Howe represents, the interests that Mr. Walker represents, and myself, and indeed others here at the bar table. That's some consideration to be given as to what the most practical and safe approach moving forward.
Yes, that's probably wise advice. Yeah.
Mr. Commissioner, the Barnes family adopts a similar position as the
Likewise, Commissioner, could I say this in addition? My interests are clearly very different from those that are otherwise at the bar table, but I have had a very strong cohort of clients who've been in court, outside the court, and consistently watching the live stream, and are intensely interested in the processes of government and the decisions which have been made by this witness and others in the process. We would support Mr. Perry's position and Mr. Walker's position.
I'll just indicate that the Sweeney family are present, as you are aware, and they would not wish to be excluded, even for a short time. They've come up here especially to hear the last few days' evidence and tomorrow's evidence.
Commissioner, could I just be heard briefly, because this is a matter that I raised on the 27th of March in respect of the statement of my witness, Mr. Miller. On that occasion, I pointed out that we are presented with a range of statements which are presented with black right through those statements. What, with respect, as briefly as I can, I'd ask of our friends from the Commonwealth is to indicate whether it's their intention now to go back to and get instructions in respect of all of those statements which have been presented to you in that form. Because this was a matter that I raised specifically on the 27th of March following the opening statements of our friends from the Commonwealth, eschewing any claims for public interest immunity and retiring to a proposition that the Land Council case gave rise to a basis purely on Cabinet confidentiality. That is, purely on the basis of the protection of the principle of collective responsibility of ministers and Cabinet. Now, on that basis, we've had to rely upon the judgment being exercised by those Commonwealth officials as to whether those principles truly sustain those redactions. And as you've just heard from Mr Walker, if I'm interpreting him correctly, he does not accept that many of the redactions, perhaps all of the redactions in his client statement, actually are supported by that particular principle. I've indicated that in respect of my client statement, I do not accept that that particular principle supports the redactions in my client statement. This is a real issue across the board now of all of these statements, and it's a matter I come from, perhaps slightly differently from Mr Walker, but one of procedural fairness, particularly for my client. But it's a matter now that's going to infect and affect the totality of those statements that have been placed before you. The protocol that was put in place on that day one was to repose in you, Commissioner, a very awkward task. That is, you would have access to all of the material and you would exercise a judgment at a particular point in time, and you have to exercise that judgment on the basis of, well, am I infected by something that was in that blackened bit, or was it in something else of all those thousands of documents I have now seen? And I'll rely upon my counsel assisting to assist me with determining and filtering as to whether that's the process of my reasoning and coming to a particular finding. And if there's an adverse element to that, I'll now present the redacted bit to a witness. This is really quite a difficult issue. At the moment, although I'm much more in my learned friend Mr Walker's camp in terms of the underpinning propositions that he puts there, because of the state that we've reached here, the position that my learned friend Mr Howe has advanced may well be the only practical way at this particular juncture till all of us can obtain instructions from all of those people who have been given witness statements and presented with them in that particular form.
All right.
Mr Commissioner, on behalf of the father of the child, we support the position as set out by Mr Perry.
Yes.
Could I ask that the unredacted version of the statement be made available when appropriate at the earliest possible time so that we can review it?
Yes. All right. I'll consider it overnight. We'll adjourn now.
Commissioner, can I raise a few procedural matters? The first is, as I said earlier, a copy of the Commonwealth submissions, and I think there was an affidavit prepared.
Yes, there are affidavits, I think 2 affidavits, which have been on the data room and available to the Commissioner and the parties since soon after the issue arose. And there's a set of submissions running to 52 paragraphs, which we also filed in the data room, and they've been made available to the legal representatives as well, and we've given a hard copy to my friend Mr Walker. Can we press upon the Commissioner a refreshment of the matters that are put out in the written submissions, but on the basis that we're content to rely upon them without adducing further matters unless you'd be assisted by them?
Yeah, no, I know that I read them at the time and they were very detailed submissions with reference to a lot of authorities.
That's right, Commissioner.
And I'm also aware that if I admit the whole of that document, it's, as you say, there is a statement of the High Court saying basically you never admit to deliberations of Cabinet inside the Cabinet room. That's why I asked Mr Walker about whether
That's right.
we could confine ourselves to being outside the Cabinet room.
I understand, and the Commissioner will need to refresh his mind as well by reference to the actual affidavits, including of the current Secretary of the Prime Minister and Cabinet Department, Dr Ian Watt, because there are some matters that he sets out which must necessarily be at the forefront of the Commissioner's consideration of the matter.
Yeah, but there's no case, as far as I know, where the former Prime Minister, the head of the Cabinet, has said, I'm very happy to tell the whole story about what went on in the Cabinet room. Now, that may not alter the law, but it's an unusual case, isn't it?
Commissioner, can I say a couple of things? It is an unusual case, and we readily accept that there are real and significant public interests in favour of the ventilation of this material.
Oh.
I'm not here to try and persuade you that there aren't any public interests at play in favour of the position for which Mr Walker contends. That's no part of my instructions or my advocacy. We accept the existence of those real public interests and their significance. We do, however, press for the existence of real public interests of a countervailing kind in favour of non-disclosure, and we would just ask the Commissioner to undertake the balancing exercise contemplated by the authorities. If you reject the claim, we press the intermediate position by reference to the express statutory powers given to you, bearing in mind that that position ultimately allows for the possibility that you will release a transcript that becomes publicly available. And then if you're against us as to that, then, subject to my instructions, we'll abide the ruling and the Commission can proceed.
And will you take some instructions about contingencies overnight?
Indeed, sir.
And
could I just say this, with respect to the notion that the current statement is a Trojan horse for a revisiting of every redaction from every statement is quite specious with respect. Counsel assisting is positively satisfied that the Commission's processes were not unduly interfered with by those redactions, and the questioning of the witness has demonstrated that the protection of the witness and the integrity of the Commission process could accommodate the redactions, and no one invited you to revisit them. And with respect, we would strenuously ask the Commission to simply rule on the PII claim in respect of this witness's statement without the notion that it has ripple or downstream effect on every other redaction in every other statement.
thank you. We'll adjourn until 9 in the morning, but we won't be starting with Mr. Rudd in the morning at 9. Is that right, Mr.?
That's so.
But we have to finish with him. What time do you need to go tomorrow, Mr. Rudd?
I can stay tomorrow as late as you wish. I have arranged a flight late tomorrow night to attend to business commitments everywhere else, but I'm in your hands, Commissioner.
Thank you.
Commissioner, would it save time if I were just to spend a couple of minutes now saying what I want to say about Mr. Howe's written submissions? I can do it here and now and
all right.
Save some time for tomorrow.
Yes.
I only want to go to Northern Land Council. That's what, for all the reasons my friend has already said, that's the place to go. 176 Commonwealth Law Reports 604. And the two passages, with great respect again, not surprisingly, that my learned friend has cited in his paragraph 26D are the passages that you would find useful. And the key is this. The court has not said, that is, the High Court has not said, that the immunity which attends cabinet secrets so as to answer claims for compulsory disclosure in litigation or by extension to tribunals such as yourself is an absolute rule. The court has not said that.
No.
Now, there are reasons why they have not said that, because obviously a public interest as significant as the honouring, I stress that, the honouring of cabinet solidarity being at the heart of responsible government and parliamentary democracy is not something which ought, in the nature of things, it being in the public interest, trump other public interests such as the administration of justice. That is why, precisely, there will be such extreme outcomes as a criminal trial being permanently stayed out of deference to the injustice that would be caused were it to proceed and cabinet secrecy maintained.
My recollection, though, is that the case distinguishes criminal trials.
And my point is this. And so the language used by the justices is to acknowledge that there would need to be cases indeed exceptional for the immunity not to be enforced. So we have the importance of the principle. My client is the last person to detract from the importance of the principle. We have the fact that that leads to, in all but the most exceptional cases, the immunity being observed by courts. Observed not by imposing secrecy on proceedings, but by declining to receive and act on the material. That's The heart of the immunity is not against publicity that would only engender a justified suspicion by the people of their own government, but rather that there won't be a poring over cabinet secrets by other agencies or organs of the state, such as a court or a royal commission. It's cognate with parliamentary privilege, the Bill of Right, preventing proceedings in Parliament being called into question or impeached in any other place. The significance of the quite explicit reservation of the exceptional case is that one would then look today for what it is about this case that makes out an exception. And the answer is so obvious. There has never been a Royal Commission which calls in terms for examination and normative assessment, right, wrong, good, bad, careful, careless, of cabinet decision-making, processes leading up to, in and devolving from the cabinet decision. As my learned friends for the Commonwealth have drawn to attention their written submissions, 26C, have noted, the High Court specifically pointed out that it was difficult to conceive of a case, quote, where the disclosure of the records of cabinet deliberations upon matters which remain current or controversial would ever be warranted in civil proceedings, unquote. Their Honours did not have in mind preventing a former Prime Minister from talking about the cabinet process to a Royal Commissioner commanded to report on the cabinet process. In other words, it's the current government that said of something nearly current, and obviously it thinks controversial, that there ought to be a Royal Commission into the cabinet process. That fits to a T because of its historical uniqueness. No government has ever done that to cabinet secrecy before, ever. Query whether it'll ever be done again. That's the exception. It's historically unique. There cannot be a better literal description of an exceptional case. It's probably never occurred to any government beforehand. It probably won't occur to any in the future if cabinet secrecy remains an informative principle of our system of government, which it probably will. That makes out the exceptional case, and with great respect, the way you have in the exchanges between you, me and my friends have described the matter entirely encapsulates the way we should proceed. One can't have a little bit of publicity on the matter. You have to have publicity on the whole matter once it's been committed to you for report. May please you.
Thank you. Thank you. Now, sorry, Mr. Kime's been standing up.
Yes, I just would seek that my client, Mr. Martin Sweeney, be allowed to proceed with his statement tomorrow. It'll be very short, less than 5 minutes. The other person who was arranged to come back tomorrow is Mr. Leviton to complete his evidence. That's Mr. Bradley's client.
Your Honour, yes, I think Mr. Howe is in the process of examining Mr. Leviton, and my understanding is Mr. Leviton's availability is that he can come any morning. He just can't come in the afternoon. So, if for programming purposes you prefer him to come on Friday morning, or if you're considering sitting next week, morning next week,
we'll do that.
We can look at that.
Look, talk to Mr. Wilson about it. But at the moment, we'll do Mr. Kime's client at 9 o'clock tomorrow. Yes. That will be reasonably short, and then we'll carry on with Mr. Rudd.
Please. I thank Mr. Bradley for that.
Sorry.
I thank Mr. Bradley for that intimation. We had arranged Mr. Leviton to come tomorrow morning, but we'll make alternative arrangements.
Yeah, I think that's right. Yeah.
9 o'clock tomorrow.
9 o'clock tomorrow. Thank you.